Courtrooms across the state, there's a new focus on caseloads.
And I'm grateful that the court has acknowledged that this is a crisis.
Matthew Sanders, the director of King County's Department of Public Defense, says every year attorneys are up against a tall task.
The statewide standard for the last 40 years was 150 felony cases.
A review led the Washington State Supreme Court to consider reducing that from 150 to 47 felony cases a year, causing critics to voice concerns.
I am the director of the small county public defense office, and in short, and not being dramatic, this would completely destroy my office.
Last year, some said the changes would cost hundreds of millions of dollars.
The proposed standards would have the effect of effectively tripling the number of attorneys needed to handle public defense cases in Washington.
Even now, counties struggle to fill open deputy prosecutor and public defender positions. We are already beginning to see the nightmare scenario where suspects of violent crimes are released because public defenders can't be found for timely charging.
Despite the pushback, the court is moving forward, adopting the new rules.
We've completely shifted our infrastructure and our planning around these standards.
Sanders welcomes the lower caseload limits, but does not like the timeline, with local governments being given a decade to follow through.
I can't help but be disappointed that the court has opted in this preliminary order to adopt a 10-year implementation timeline and has encouraged but not required case weighting as the standard.
Case weighting, where cases are assigned credits based on complexity and judicial workload, is something Sanders hopes justices revisit and make a requirement as they continue to evaluate the new standards. In Seattle, Natalie Swaby, King 5 News.